Welcome to the Secure Connections podcast, sponsored by IOTSA, the Internet of Things Security Services Association. I'm Brian Sherman, Content Director for IOTSA, and joining me today is a frequent contributor, attorney Bradley Gross. In addition to his role as founder and president of the law office of Bradley Gross, he's a noted speaker and author on so many tech-related legal topics that I've lost count now. Today, we'll discuss ways to minimize your MSP's legal liabilities from beginning to end. Welcome back to the Secure Connections podcast, Brad.
Good to be here, Brian. Thanks for having me.
Good. Oh, we're always happy to have you back. I learn so much every time I have a chat with you. So
well, that's good.
That's a great thing. And hopefully our listeners do too. So how are you adapting to this new business normal?
The new business normal is not so new anymore, right? I mean, what are we, 6 months into it? 7 months?
7 months into it, yeah.
Something like that. It's pretty crazy. I can tell you that I've enhanced my background green screen capabilities. I've done that. I've learned the inner workings of Zoom and Microsoft Teams and so forth. And as far as staff is concerned, we have distributed the workforce. So everyone is working in different places and it's all been coordinated. It's coming along, right? Just as we figure it all out, everyone's going to end up going back to work. So,
maybe not.
Maybe not. That's, you know what? You're not wrong. Maybe not.
It's good to have options. So I think many MSPs are very happy to go. Every time I talk to them, it's like, it's amazing. Everything worked. My clients finally realized why they were paying us money every month. It's a good thing.
Right. No, you're that's true. That's true. We'll see. But I think that after a few months, I think we've got it down pretty well.
Yeah. Well, you're down in Florida too, so you're further ahead than some of us as far as reopening too.
We're ahead in some ways, behind in others. So that's another podcast, though. I think.
Yeah, we won't talk about those legal issues. But so October Cybersecurity Month. Are you planning any activities to celebrate? You got things going on right now?
Yeah. So what do we have planned for October? Nothing really too much. I think that I'm going to continue studying for CISP certification, which is good, right? I'll be an attorney CISP. I'm going to be finalizing the curriculum for a law school class on responsibility, corporate responsibility in the age of big data, right? Which revolves and relates to security and privacy and so forth. So I'll be teaching that at St. Thomas Law School in the spring of 2021. So that's good. I'll be doing that. Cool. And I'll be figuring out what I should wear for Halloween. I mean, that's really it. I think that's...
well, Professor, that sounds great. That is awesome. I'm glad to see they're keeping you busy either way. But
they are. They certainly are.
So awesome. So let's get back to today's topic and start with the basics. So before an MSP firm onboards its first client, or its 50th client for that matter, however they're at in the process, what documentation do they need to have in place? I keep getting asked this question, and I keep pointing them back to different podcasts, but I'd like to get that all in one place.
Get it set right now. Let's get it set right now. So as far as onboarding is concerned, you have to think of the process, right? You have to think of the where onboarding fits in the overall scheme of things, right? So onboarding is a process that occurs before monthly recurring, right? Before monthly recurring managed services, but it occurs after there has already been some sort of audit to determine what needs to be done and, what the environment is, what the environment has and so forth. Regardless of whether you are at the point where you are performing an audit, performing onboarding services, or performing any sort of managed monthly recurring or project service of any sort, you must have in place at that point, some sort of statement of work that describes what you're going to do, how you're going to do it, when you're going to do it, and so forth. And that statement of work needs to be governed by a master agreement that covers your legal end of things, as well as situational realities, which we'll talk about in a little bit, I'm sure. The question that I'm often asked is, well, if it's only onboarding, right? I mean, we haven't begun the managed service yet. Do we really need a whole statement of work? And do we really need to have a master agreement governing a statement of work when all we're really doing is sort of moving from one or helping a customer transition from one situation to another? And the answer is unequivocally and literally universally, yes, all the time. The idea is, and we just wrote an article, in fact, for your website on this very topic, that liability attaches at any point that you're touching a system. Liability is service agnostic, it is project agnostic, it is cost agnostic. It doesn't really matter. It doesn't matter what you're doing. If you're touching a system, something bad could happen. And it's not going to be enough to say, well, we were just onboarding. I mean, that's all we were doing. So, how much liability can we have? Well, if you touch a system, you own it. Therefore, at the onboarding stage, like any stage, you need to have a statement of work in place, right? And you need to have that statement of work governed by a solid master service agreement protecting you. Otherwise, you're really exposing yourself to quite a bit of liability, regardless of the size of the project.
Right. And I know we hear from time to time, MSPs that are trying to do the right thing and help out other friends with friends networks, business networks. Right. Times.
Sure.
It's, there's a lot of things I think we do without thinking of the liability of it behind it. But what you're saying is, before you jump in and touch any network, make sure that you have your legal basis covered.
Of course, we're all friends until we're not friends, right? And when we're not friends, we're really not friends. And it's not going to be enough to say, I was just doing you a favor, or, I know this really wasn't covered by what we were supposed to do, but I did it for you anyway. So if something goes wrong, I really shouldn't be responsible. None of that applies when bad things happen. Right. So when bad things happen, you want to be able to look to some sort of agreement, to something in writing and say, this is what we're going to do. This is the liability that we were allocated. Here's the responsibility and liability you, Mr. Customer, you were allocated, and we move from there. That's how it should be done.
Very good. So let's throw some other people into this relationship.
Okay.
Co-managed IT. It's a growing opportunity for the channel, especially cybersecurity. Sure. Many MSPs, may play a supporting role to internal IT teams or collaborate with other MSPs, master agents, vendors in some cases. What contract language changes are recommended or needed for these type of relationships?
So under the co-managed platform, you have to sit back for a moment and realize the paradigm under which you're working, right? You have to, think of it like a Venn diagram, right? The circles, and then they intersect at a certain point. And one of those circles is the stuff that your internal, the IT department from the client is going to perform. Then the other circle is the stuff you're going to perform. There's always going to be an overlap, right? There's always some sort of overlap. The question that you need to address in your documents at that point is, how do we handle the situations that arise with the overlap, right? First of all, for example, you ask yourself, what is the overlap, right? Where might we intersect? Do we all, for example, have the same passwords? Do we all have the same keys to the kingdom? Do we all have equal access? If we do, what might occur as a result of that? You always, it's nice to think of bright sunny days and say, I'm sure this is going to work out great. But you also have to think of the rainy days, right? When you're doing something, they're doing something, what they're doing interferes with what you're doing, or vice versa. They may do something that messes up the system. And now the question is, who's going to fix it, right? What conflicts? Think about the conflicts that could occur in this type of paradigm. The other thing that you have to think about in a co-managed environment, right, is you have to think about whose judgment, whose opinion will ultimately matter, right? In that overlap on that Venn diagram. We can discuss it. If you're the internal IT department and I'm the service provider, we can discuss what should be done. Maybe you'll say we'll do A, B, and I'll say we should do B, C. Ultimately, who's going to decide? That needs to be addressed because you don't want infighting and you want to speak with one voice with a certain outcome. And of course, the other thing that you really need to think about that service providers always need to think about is remediation of a problem. When something comes up as a result of an internal IT department's activities or some other third party's activities, who resolves it? Who is the superhero in this particular situation, right? Who is going to fly in and say, we're going to handle it? And then you have to ask yourself, do you want to handle it? Is that something you really want to do? You know, if you're going to superhero any sort of situation, maybe the way to do it is superhero it at the statement of work level. Talk about who's going to do what is covered as far as remediation is concerned, diagnosis and remediation. Handle it at that level, and then you won't have the issue later on when these things happen. Right? When these things happen, that's not the time to try to determine it. So co-managed environment can work, assuming that you have high fences, right? As they say, high fences make good neighbors. Mm-hmm. A high fence is a good statement of work that says, this is what we're going to do. This is what you're going to do. If there's a conflict, we'll discuss it, but this person will control. And as far as remediating or diagnosing things that happen that is or is not covered, that's the key to a good co-managed environment. That needs to be in your document. If it's not, you're bound for problems.
But now you mentioned where there's things that are not in the statement of work, for example. Those things I would assume you'd want to have documented too, if there's changes.
Most definitely.
Okay.
Most definitely.
Do ticketing systems help with that too?
What's that? I'm sorry, I missed the question.
Do ticketing systems, so documenting in a ticketing system, is that sufficient, or should that also be done outside of that?
Well, as far as documenting problems, I think that there has to be internal consistency within a business to make sure items aren't missed, right? So if you're going to use a ticketing system, then use it all the time. What we often see is, I'll have clients that will implement some sort of ticketing system from any of the great vendors that are out there. And then when I have a conversation, I'll say, well, do you use it? Well, sometimes we use it. Sometimes we don't. Well, what do you mean sometimes? Sometimes salespeople go around the ticketing system. They get direct dials to their cell phones and so forth. And if that's what you're doing, then you're asking for problems, right? Because I promise you that something will be handled directly between the tech and the customer. Your the company won't know about it. Something will go wrong. And then the question is, who's going to who's going to diagnose it? Who's going to remediate it? Is it going to be covered? There's going to be project and scope creep. So my suggestion is, if you're using a ticketing system, use it consistently. And I think that you'll be okay.
Yeah, that makes sense. So when we're talking about all the documentation needed up front, are there MSP specific issues that attorneys unfamiliar with their industry may miss? I'm thinking everybody knows an attorney. They may want to get them involved in running, putting together their documents, but what could they miss if they're not familiar with IT services? So
the whole idea, when drafting a contract, it's especially applicable to the managed service and the technology service provider industry, but it really applies to most service industries, is that there are situational realities. And I'm actually putting a few chapters of this subject in a book that I'm writing on exactly this, situational realities. There are, in any industry, especially in the MSP industry, there are realities that occur. And they occur when you are providing a service and something happens. It could be a mistake, could be a miscommunication, a misunderstanding, or it just could be something, there's an issue that we're not sure about. These kinds of things happen all the time. And you have to be up on those, right? You have to be up on that. Transition services, right? You have to think about the end at the beginning. You have to think about the end when you're writing a contract, and you have to understand as counsel to an MSP, what happens at the end of a relationship with an MSP, right? What happens? Well, a few things. First of all, things end. We know this. Usually not well, right? Usually not well. It is very rare, really rare, where a customer walks away from an MSP saying, you know what, you guys were fantastic. You helped us. You answered all of our questions. Your price was phenomenal. We're out. We're going somewhere else. Usually it's because, there's finger pointing, bad things are going on, right? And that's the circumstance under which a contract is ending. And then you have to think with transition services, what about the licenses? Who's going to handle the licenses? And how long would a transfer take? How about this? Ready? Software agents. Can a customer just say, I'm out, and remove the software agents? I mean, we have handled a lot of matters in which customers of MSPs have said, we're out, we're transitioning out, we removed the software agents. Problem, the way they did it, The third party, whose agents are on there, they're still billing because they didn't deactivate them. They just removed them, right? Removal doesn't equal deactivation. And that is one of dozens of little things that you need to know about this industry when you're writing a contract. Otherwise, right? Otherwise, the issue comes up. Well, we removed your agents. Well, you shouldn't have done that. Why? Because we're still being billed, which means you have to pay for it. Where does it say that in the contract? I don't know. It says when it's over, and billing will stop. So it has to stop. Now what? Well, now you're going to have attorneys arguing at $300, $400, $500, $600 an hour or more. And they're going to argue very slowly with a lot of words, right? To take up time over that issue. When really, if you had something in there, if you knew what you were doing and you knew the issues related to the industry, you would have something in there that says, client will not remove software agents. If software agents are removed without our authorization, billing may continue, and you agree to continue paying those bills until the agents can be successfully deinstalled, deactivated. That is something that you need to know. And there's a lot of that, right? BYOD, regulatory compliance, resale of upstream provider services, so many realities. So you really have to know what you're doing in this industry. You don't want to dabble in it. You really need to know what you're doing.
I can imagine the data part would be difficult enough. I mean, if you're thinking about, for example, if you're in the energy industry, like utilities and stuff, there's compliance issues, NERC and FERC and things to worry about there. But I would imagine that, in the tech industry, it may not seem complicated, but at the same point, there's a lot of issues that need to be dealt with, like you had brought up before, that it helps to have that expertise.
Of course, and you have to manage expectations, right? I mean, you brought up regulation just now. So what we have seen, we've had matters in which MSPs are providing a, let's say, HIPAA compliant solution, right? The solution is compliant with HIPAA, but that doesn't make the customer compliant with HIPAA, right? That's a piece of the puzzle. That is a tool in the toolbox. That is not a guarantee or a warranty that now this client is HIPAA compliant, but the client might think it is, right? Why would the client think that? Why would the client think that? You would think that because you, as a service provider, you didn't tell them any differently, and you should have. Maybe legally, you don't have to, maybe legally, but again, $400, $500, $600 an hour, we can argue all day long about legally whether you should have or not. I would rather you say in your agreement, I'm providing you a solution. That solution might be compliant with a regulation. That does not make you regulatory compliant. If you want a regulatory compliance solution, you need to talk to your technician, talk to us. That's under a different statement of work. It's a service we don't provide, whatever it is. Manage expectations.
No, that definitely makes sense.
Yeah.
So MSPs often run into clients or prospects who don't want to follow the recommendations. Go figure. I can't imagine. That never happens, right?
No, it never happens to me either. Everyone listens to me. Yeah,
well, especially around cybersecurity. I've heard so many horror stories of they don't want to take my advanced cybersecurity or even my basic cybersecurity. They're happy with what they have, but they still want me to manage their network, which is a big problem. What should IT service companies do when decision makers decline a service that the MSP deems necessary or vitally important?
It's a big issue. And the reason why it's a big issue is because everyone has short memories. That's the truth. Everybody has short memories. If you said to your client, listen, we think you should have some basic phishing training, right? No, how much is it per person? We don't need it. We circulate some stuff and it's okay. And then a phishing attack occurs. First thing they do is point the finger at you. I thought this was supposed to be stopped by you. I thought that this was the kind of stuff that if it came through, there would be alerts and our people would know and so on. And now it's, well, don't you remember we recommended? Well, you recommended it, but I didn't know how big a deal it really was. And now we're back to the $400, $500, $600 an hour deciding who's right and who's not. So if a customer's declining a service, I think that you need to do the following. And I put this on the technology broadcast. I have a podcast on this. It's the following. You need to put this in writing somewhere. It doesn't have to be a formal contract. I recommend what I call a declination letter or a decline letter, right? Declination letter. And a declination letter will serve two purposes. One, It will memorialize, it will put it in writing, the fact that a client rejected a service. So there's no project scope creep later on, right? There's no scope creep, because you could say you specifically declined the service, right? Okay. It manages expectations. That's an important part. So the customer knows they're not getting this service. But there's another thing, and it's crucial. There is a marketing aspect to declination letters that every MSP needs to think about, right? It is a second bite at the apple to sell the service that the client declined. And the example I always like to give is, if I create a pizza for you, and I said, Brian, I could deliver this pizza to you, right? I could deliver it to you for an extra $6, or you could come pick it up. Well, you're going to sit back and say, $6. I'm going to decline. I'll go pick it up. Okay. So I could sit there and go, I guess he's picking it up, and hang up the phone, right? Or I could say, all right, Brian, so you're going to pick it up. So you're declining the $6 delivery. All right. Let me just tell you a few things before you set out. It is raining outside. So the roads around here are wet, and there are some potholes. Just to try to avoid those. We're not that easy to find. All right. And the lighting isn't great. So, and also when you get here, the parking lot tends to get flooded in the rain. So you're going to have to circle around a little bit, but okay. So you're going to pick that up, right? By the time I'm done with you, you're not only going to want me to deliver that pizza, you're going to want me to hang out and watch TV, right? The idea is that I've talked to you about the parade of horribles that are going to occur because you didn't pick a $6 delivery option. Right? A declination letter serves the same purpose. Not only does it memorialize, right? Not only does it set expectations, but if it's written correctly, you should be telling your client what they're not getting, what bad things might happen, right? And specifically say, if these things happen, it's not covered. It's a billable event. Okay, so now just sign here. Much of the time, I've never done a formal poll, but I could tell you that much of the time, clients will say, "Now, wait a minute, what was that delivery option again? Right? What was that? Was that $6? I mean, couldn't you make it $5 or $4? Yeah, we could do $4. Good, done. Right? It gives you that extra bite at the apple. I highly recommend it.
Yeah, no, that's a good example. I guess I'm thinking about, I grew up in Western New York, so chicken wings are huge here. Uh-huh. The big catch for some of the wing places over the last 5 years is to add a disclaimer for the hottest wings. So you must sign these. I'm sure it does minimal or nothing, but at the same time, it really makes you think, wow, that's going to be hot.
Yeah. It's marketing. Yeah, it's funny.
Yeah, it is marketing.
Growing up, my dad always would come out. He said, one day I think I'm going to open up a kindergarten and not let any kids into it. Just say only certain, highly educated, perfect children will get. He said, we'll get floods of applications. Everyone will want to get in, right? Because it's marketing. I'm limiting right? Same with you. Marketing a wing. I need a disclaimer before you bite this wing. Really, it's all marketing, but it works.
Yes, but it works. Makes people think it's hotter. Yeah.
Right. And in this particular case, a declination letter at the end of the day also has a good legal and an important legal aspect to it, right? Okay. Which is protecting you from project scope creep, right? Protecting you when the client turns around and said, you didn't explain this enough to me. That's on you, not on me. And now we don't have to bring in lawyers to discuss that issue.
Yeah. So the defensibility of those contracts is good. I mean, that's been one of the questions I usually get from MSPs. Sure. They've heard some people say that, if I get them to decline, it is more marketing than it is legally binding. What is the defensibility of it?
The declination letter is it's not a contract. It's more of I'm putting you on notice that I've offered this to you and you declined it. Now, the question, of course, is what if a client doesn't sign it? Right? What if you send them a letter and the client doesn't sign it? What do you do then? Right? Does that mean, or could it be interpreted that the customer does want it and now leaving it open? So if something bad happens, they can point the finger. But if you don't provide it, they don't have to pay for it. Right? Where are we? The answer is this. Okay. You can lead a horse to water, right? As they say, but you can't always make them drink. You offer them the letter. If they sign it, great. If they don't sign it, wait a little while, offer them the letter again, twice. That's my motto. 2 times. Maybe you overlooked this. I know we're all busy. I just wanted to remind you of what you've declined. Here it is again. Okay. If the client doesn't sign it at that point, you're done. Make a note in your file. This was offered on this date and this date. It was either, not signed or I got no response, and move forward. That's the best you can do. I wouldn't overdo it and keep saying, 3, 4, 5 times. It's not required. It's not required. It's not a legal requirement. And you just have to show that you acted reasonably. And if you show you acted reasonably and you offered this thing to them and they didn't sign it, you're fine. You're fine.
Okay. Now, I know we were talking about the beginning and these are the things that go on during, but let's talk about the end part that you need to be thinking of up front. You mentioned earlier, no one likes to think about the end of the business relationship, but it can be a common occurrence in the MSP community or many communities, honestly. What are some issues with offboarding that MSPs need to consider?
So the offboarding process is often overlooked because people just simply, when you think about the end, you think, all right, they'll leave, they'll pay their last bill, and that's that. Well, what about the client that doesn't pay his or her last bill? What about that client? What about the client that doesn't pay the last bill, but demands that you return the data? What about the client that doesn't pay the last bill and demands that you turn over all administrative passwords, right? So they can more easily have another, provider step into your shoes and move forward. Are you required to do it? Are you? I mean, the answer is, and if anyone says based on the facts I just gave you, oh yeah, here's the answer, well then he or she has no idea what they're talking about. No idea. The answer is it's a creature of contract. Okay. If there is no contract, if there is silence on that issue about what do you have to turn over when you haven't been paid, right? When they haven't fulfilled their end of the agreement, then it becomes a fact-based kind of thing. What are the expectations? What's reasonable and so on. But if we have a contract in which I say the provision of the passwords at the end of our relationship is dependent on the payment of your last bill, right? You cannot set off amounts based on whatever issue we're having. You have to pay your bill. We'll give you the passwords. Now you have a contract. Now you have something in writing. That's an issue that people need to think about. And there are a lot of stories, if you Google it, about service providers being hauled into court over not providing the final step, right? That last mile of service, the passwords. I think there was a guy in Atlanta who was threatened to be arrested or might have been arrested for holding back the passwords. And all of these things could be resolved with a good contract, which goes back, I guess, full circle to what we were talking about earlier. These are the realities that a good MSP attorney needs to think about, right? At the end of a relationship, what might happen? Might it be that we wave goodbye? It's so good seeing you. I'll see you next week at the house. Yeah, maybe. That's like Loch Ness Monster. I've heard about it. I've never seen it, right? But I've heard about it, right? I think it's like a legend.
Right.
You have to think about those kinds of things. So at the end, think about transition of data, think about payment, think about transition of passwords, think about licenses transfers, think about software agents, as we discussed earlier, that may have to be deactivated, return of equipment, right? Return of equipment. Do they return it? Do you have to pick it up? When do they have to return it? At what point can you just say, I'm going to charge you for it if I don't get it back? These are the issues. Think about bad things. Sometimes that's what they pay us to do. Think about bad things.
Yeah.
But that's how you end and avoid disputes. That's the key.
Makes sense. So even things like, hardware as a service is still a thing for some of them to think about, passing the keys with that and the costs of it on. And
100%.
I guess it goes back to whatever services you're providing to figure out how to end of life each of those, or not end of life, but transition those over to somebody else's responsibility.
Absolutely. That's
warranties.
People in their zeal to get the deal signed, they don't think about the end. And the end is where you end up spending the most amount of money, right? True. That's where you end up spending the most amount of money. So it can't be ignored. It must be addressed initially, early on.
So this is like your prenup then, huh? When you're building your relationship is.
I guess so. Although it's not as controversial because unlike a marriage where you don't want to think it'll ever end, right?
Yeah.
With a business relationship, every business relationship ends, right? It might end because you're bought out. It might end because I'm bought out. It might be because a meteor hit your building and took you out. I mean, the proverbial bus might have hit you. It's always going to end. So it's a little bit less controversial than a prenup, but I think it has the same foundation. Yeah.
But you brought up a good point with M&A is if I never think about it that way, but if the MSP is bought out,
right,
you need to have those stipulations in there as well, right? What happens if 100%. This happens?
That's right. Always these conditions.
Or the client.
These are the situational realities that need to be in the documents.
Yeah.
And there are so many of them. And, you really need to sit back and think. People just write out, oh, okay, so I get it. I'm going to give them advice. They should take my advice. Transition, you have to pay me, and I'm not giving you a regulatory compliance solution. Okay. Gotcha. I mean, but that's not enough. There are so many of them. What if the client is a jerk? What if the client is really just a bad person who threatens your text but pays his bills? I had a case like that where the client was a law firm. And they just threatened the text every time the text came there. You're not operating under the SLA. You're doing things wrong. By the way, they were operating under the SLA, but the client was a lawyer, and the customer was a lawyer, and lawyers don't know what they're doing. So,
but you're intimidating either way.
But you're intimidating, and the MSP comes to me and says, "What do we do here? I can't get a tech to go to their office. No one wants to go. They feel like they're going to be mentally abused, but they're paying their bill. Yeah. They're paying their bill. What are you going to do?" And the answer is, well, because the MSA was not written correctly initially, right? About $20,000, $25,000 later, we figured out what they could do. It's an unnecessary expense. Write the MSA to have situational realities in there, and you're going to avoid $20,000 in attorney's fees. I mean, this isn't for research and development. This is just spending it on attorneys to argue. Yeah. Don't do that.
I think the forums are just filled with potential what could be from sexual harassment of techs, and I've seen that one to sexual harassment of the owner of the business, even in many cases. Yeah, I mean, there's so many. We could probably go on for another hour talking about situations.
The realities and bad behaviors and so forth. It's a reality, especially now that a lot of distributed workforces, like we started off talking about, people are distributed. You have a lot of different locations, so people are going into even home locations, right? A lot of different dynamics going on. Yeah. You need to think about that.
Yeah, that part could be scary. Well, awesome.
Sure.
Well, Brad, it's always awesome to have you on. And even though I leave kind of scared, I leave kind of scared sometimes of the things I need to be thinking about. But that means you're doing your job. So
right, a little fear sometimes is not a bad thing. Keeps you sharp.
So any final suggestions on the legal aspects of the MSP client lifecycle relationship, I guess you would call it? We've kind of talked from beginning to end.
That's it. That's really the key. When you're doing these documents, think about it's like a movie, right? Think about the beginning, the setup, right? Lights, camera, action. That's the middle. How are we doing things? Who's doing what? How are we allocating responsibilities? And then you got to think about the end, right? How does this play end? How does this film end? Because it's going to end. So think about that. I have a podcast, the Technology Bradcast. People go there. It's www.technologybradcast.com. Got 25, 30 episodes up there right now, all about this kind of stuff. It's free.
Awesome.
People can listen to that. Right.
I'm a frequent listener. Yes. Good. That's awesome.
Good.
Yeah, fantastic. And you have a recent blog that's up on the IOTSA website too. You're a contributor. We appreciate that. So stop by the IOTSA blog, check out what Brad has to say, and also your page. You're a frequent contributor, so they can learn a little more about you from IOTSA.
I enjoy it. Yeah.
Awesome.
Thanks for hosting that.
Awesome. So on behalf of IOTSA, I'd like to extend a big thank you to Attorney Brad Gross for joining me on this episode of the Secure Connections podcast today. Be sure also to stop back at iotsa.com for new episodes every week, sometimes two. We get a little out there sometimes and go crazy and add 2, 3, and security panels. So it's good. Lots of things to see and hear. Have a safe and secure day, and thank you again for listening.
Take care, Brian.